All right, good morning, everyone. Welcome to Iconic Delaware Cases. So the seed for this program is actually a series of materials that the folks at UPenn Law put together back in the late 2010s, where they looked at a bunch of, I guess I would call them household name cases. You know all of them, Van Gorkum, Unocal, Revlon, et cetera, et cetera, et cetera. So in connection with each of those cases, they put together a series of interviews with some of the main participants in the litigation, and they also assembled a set of primary materials. So back in, I think it was 2022, my Institute for Corporate Governance and Finance co-director, Ed Rock, decided that it would be a good idea to set up a seminar around those cases for the benefit of our students. And he actually ran that seminar together with Matt Mallow, who's sitting there in the front row, and Travis, who joined them 1 year later. Then, I think it was last year, Ed was going on sabbatical, and he asked me, hey, do you want to sub in for me? And I simply couldn't pass up the opportunity to share a room with Matt and Travis, so I said, hell yes. And in the course of teaching the seminar, it dawned on us that that the oral histories materials were a really terrific set of materials, but there was a sort of unfortunate side to them, which is that they had stopped at some point. And the creation of what we now call iconic cases is an ongoing project in Delaware. Every year, a couple of cases come out that have a plausible claim to becoming household names. So we decided, well, how about if we at the Institute for Corporate Governance and Finance try to set up a recurrent program where we identify some of these household name cases as they come about, and then bring some of the people who are involved in the litigation for a discussion. Part of the rationale is all of us are familiar with these cases, but for the most part, when they get crystallized, they boil down to a number of bullet points at the end of law firm memos saying, okay, these are the key practice points, right? But often when you look at these cases, there's much more to them. The path that leads to those practice points at the end is often pretty winding and invariably really, really interesting and often forgotten. So the point of convening these panels that hopefully will become an ongoing effort from the Institute going forward will be to try to, again, build a record for all of those long, winding, interesting paths leading to those practice points. So the first case we picked to try to engage in this discussion and to launch the program is Rural Metro. And to join me in sort of walking back through that winding road are the person who decided the case at the Chancery level, Vice Chancellor Luster, the person who brought the case together with the folks at Robbins Geller, I see Randy sitting there at the front, Joel Friedlander, Alan Stone, who was the lawyer on the RBC side, the defendant side, ultimately, and then Rob Knauss, who joined Warburg Pincus as their general counsel right as this case was going to trial, give or take. Right. Something like that. Yeah. Good. So let's get started. So I'll start with you, Joel. So the deal was announced late in March 2011, and then like a week later, Randy, Robbins Geller, filed a case in Arizona. The Faruqi law firm filed a case in Delaware. Then I guess you guys joined efforts and you tried to bring the case in Delaware, and then you ran a race to see if you could get appointed as lead counsel. Leo at that point said, well, not now. So we'll side with Faruqi. Then, I mean, as things unfolded, the Faruqi guys focused mostly on disclosure, and at some point they arrived at an MOU with the defendants, and they were moving forward toward a settlement, and you guys decided to challenge it. So yes. Do you want to walk us through the decision of that challenge? First of all, let's look at it from the ex-ante perspective. Exactly what was going off in your instrument panel, so to speak, that led you to think that you had something here, that in turn led you to invest resources, your time and your money in hiring experts and so forth and so on, which then enabled you to challenge this in a successful way.
Right. So there's two steps to it. Originally Randy brought the case over from Arizona, as you mentioned, and I'm sure we spent a little bit of time looking at it, but it's in retrospect not very much time, compared to what came later, and it was actually there was no leadership contest. There was a leadership contest. There was no leadership hearing for reasons that are mysterious. An order got entered a week before the leadership hearing, appointing Faruqi, like signing Faruqi's order without any explanation, and that was a bit of a mystery to us. But we always had this idea oh, I'm sure it'll be a disclosure settlement because that's the way these things always ended, and we will, let's see what they come up with and we'll plan on opposing it. And so when I think intellectually what I remember is that period of like analyzing the emails that had come through and the banker books, you know, for purposes of teeing up a disclosure, Jeff Gorris is also here. He had recently joined the firm, and I remember he and I were looking at it. And one thing that really intrigued me from the outset was that Moelis's banker's book. And the thing about it was it had a football field, like, as we later learned in litigation, I don't think it ever happened before, and it's probably never happened since, where the way they were valuing the company for their DCF, they said with or without NOLs, with or without this acquisition plan, because this company, Rural Metro, was an ambulance company roll-up. And so, you know, the high and low, but with just the brackets, it was all mushed together as one range. And when you disaggregate the range and look at the book, you see that there's no value associated with the acquisition plan. So I remember thinking to myself, like, if you're the CEO or if you're any observant reader of this book, you might think, well, okay, Moelis is either these really genius management consultants who realize that the CEO's whole plan doesn't make any sense because it adds no value to the company, or they screwed up the valuation. And so we retained Lexicon, Kevin Dagis, that did an expert affidavit and realized that frankly, I think they'd screwed up the valuation, and in terms of the valuing the acquisitions. And then we sort of cross-checked and it looked like RBC had done the same thing, although it wasn't as apparent from their book. And that's what really intrigued me, was that it looked like it was formatted in a way to mislead, and that the valuation seemed off really about what the company was worth.
So, Travis, this lands on your lap in a somewhat mysterious way. Do you remember why it was reassigned to you? Because initially it was on Leo's.
Yeah, so it's actually not mysterious to me. I do remember. Part of this is that we were in another era. So we were in another era where it was the sue on every deal era, and these settlements were happening, and every member of the court, and there were 5 of us at the time, would have at least 1, if not 2 or 3 of these settlements every month. So these things were fairly ritualized and routine. And what I remember is, Leo had a conflict with the date when he had scheduled the hearing. And because you send notice out for these hearings, it's somewhat awkward to move them. We always say in the scheduling order that this can be moved without further notice, but as a practical matter, you don't like to move them. And so he asked me if I would cover the settlement hearing for him. And I've had colleagues who've done the same thing for me. I'm always grateful for it. So I said, sure. And so that was the original idea. And then when I looked at the papers and saw Joel's objection, I went to him and I said something along these lines. I think this is really thin. I'm going to wait and hear what these guys say, but if I end up rejecting it, it seems a little awkward for me to reject something that you then have to deal with. Why don't you assign it to me so that if I reject it, it's my problem and it's not work for you going forward. And so that's how it ended up on my plate rather than staying on his.
So going into a settlement hearing, you had a reasonably well-built opinion that you were going to reject the settlement?
So it's a little bit messier than that. So I was skeptical of the settlement, but again, you have to put yourself back in the milieu of 2012, where we had just come through a decade, 2000 to 2010, where everyone was doing this. And so the expectation, and I had been part of this mechanism in practice, I'd represent a lot of defendants in these settlements. So the expectation was that these settlements got approved. And we'd gone through, since I'd been on the bench, there'd been some early settlements that weren't approved. I had rejected some. That had not been received well. Right? There had been a lot of pushback on that idea. How can you possibly not let the defendants settle these cases? We need finality. These are helium claims. We shouldn't have to fight them. We should be able to give supplemental disclosures for them. And there was some truth to that. So none of us would reject settlements lightly. This one, not only did it have the issues that Joel identified, but there were also hints of conflict in the record. And another sort of historically contingent point, because there had been this earlier wave of settlements that had been rejected, the plaintiffs' bar had gotten back to actually doing some real confirmatory discovery. There was a period of time in sort of the late aughts when they weren't just doing anything. I mean, like nothing. I mean, maybe get a few documents, maybe get one deposition or something like that. But because there had been this little period when they were getting rejected, here they got maybe 3 depositions, and they also got a meaningful quantum of documents. Yeah. And so the objection was not only able to point to the molus issue, it was also able to sort of preview what ended up being your main theory of the case, at least as I understood it, which was that you had Coliseum and Shackleton making the initial move, and then you had bankers pushing the deal, and so there was this frisson of self-interest in addition to the banker books. It wasn't just playing with the ranges.
Right, I left out of that. So there was the molus angle, which personally I found very intriguing, and then the other issue that I found intriguing at the outset was that the chairman of the board, the chairman of the special committee, was a young guy named Chris Shackleton, like early 30s, and Rural Metro had become a 20% holding in its fund because its stock price went up. And then from the emails, he had gotten mad at the CEO, Domino, for not trying hard enough to sell the company. He'd been in the company for about 5 years. And so there was this friction, and then it seemed like Domino then got on board with selling the company. Yes. So there was some, it wasn't really well developed in the depositions, but there was some underlying emails of some, looked like some boardroom drama.
Yeah, boardroom drama. So the direct answer to your question is I came in with serious doubts about the settlement. I had questions that I wanted answered, and I was skeptical of it. But I also, again, we're living in this world where to not approve a settlement is still viewed as this like big thing. So I didn't come in, strongly inclined to reject it. I thought it was, and I said it at the time, something of a tough call because of this world we were operating in, where this was still business as usual in a lot of ways.
So ultimately, Travis rejects the settlement. He puts you guys in the driver's seat, so to speak. Right. And then you file your amended complaint. You sort of previewed what the main thrusts of that complaint were. Do you want to elaborate on them a little bit more? And in particular, what I'm interested in is the kind of stuff that was not there yet. I read your complaint, and 2 things barely showed up or didn't show up at all. Okay. One is the notion of staple financing is mentioned once, right, and without any of the aura of conflict that then it assumed. And second, the notion of aiding and abetting is simply not there at all.
Right. So, right. It wasn't until we developed more fact discovery and deposed the bankers that we added the bankers as defendants, and we got the bank's discovery. So I was very leery at that point, and actually I'm still leery of ever making like a policy-based argument. Okay, plaintiff's lawyer representing a stockholder with 100 shares thinks staples financing is a bad idea. Like, is that persuasive to a court? I'd say no. Or the fact they have 2 bankers because the first one seems conflicted and the second. So there were things that were matters of market practice. And I'm always looking for like a factual argument. Like if I come before the court and say, look, this person has a conflict and it's not disclosed, or someone is out there seeking fees in another direction and they're not disclosing that to me is very rhetorically persuasive, as opposed to, hey, Court of Chancery, let's put an end to staple financing. So if that's helpful to you.
So while we're on the topic of staple financing, Rob, I want to rope you in. So how were you thinking about staple financing back in the late 2000s? Was this frequently used in connection even with public deals?
It was being used for, well, there's a difference between public and private. Private stapled financing is still being used for very good reasons, which I can go into. But it was a thing in the public world. But by the time rural came along, people were skeptical of it because a case had come out earlier, Del Monte, maybe a year or so before, which really raised the issues of a potential conflict of interest if the sell side advisor, is pushing to provide buy side financing So I think that was a case that sort of got people's attention, certainly got ours attention, and we began to look at it a little bit more skeptically. And I would say, just jumping ahead, in public deals, I don't think anybody really does stapled financing anymore. Private deals, very different.
So setting aside the impropriety or of it, can you walk me through the pros and cons of the availability of stapled financing in both private and public deals?
Well, I think in the public deal, the argument was, look, if you can provide certain financing and a buyer, potential bidder, knows the price of the financing, it eases the transaction. You know your cost, so it can increase the ability to buy and to bid. I think in the private context, there's an additional reason, which is in private deals, sellers are more concerned about having a non-public marketing period. They want to keep it private. They don't want their their customers, suppliers, employees to know they're on they're out for bid. And I think the sell-side advisors play into that, rightly so. I think there's good reasons for it. They say, look, if we can provide the financing, you don't have a bunch of bidders going out and calling a bunch of bankers and other financing sources where the potential market auction gets leaked out there. So I think that's another good reason for stapled financing, certainly in the private context.
So, Alan, when do you come into all of this, and how baked in was the record at the time you came in?
Sure. Excuse me. First, I should, thank you for having me, but I really want to say thank you for letting me relive my nightmare. I got involved very, very late. So the complaint against the bankers was filed shortly before trial. It was in March of 2013, I believe. I had been involved for a few months before that because RBC had received a subpoena, third-party subpoena, to provide documents and a witness in connection with the discovery of the case. But they were not a party, and my job was simply to make sure that they provided the documents requested and prep the witness and defend the deposition. So that was my thinking, and then when RBC was sued in March, it became much more serious.
What were your first impressions looking at that record?
Well, looking at the record, and looking at the theory, I thought it was, a novel, in somewhat novel theory, although there had been mention before in the case law about the possibility of investment bankers being accessories, essentially, to breaches of fiduciary duty. But it's not that we didn't take it seriously. We just thought that given the case law, that would be a difficult road for the plaintiffs. The record itself, it was difficult. I mean, we certainly understood that Tony Munoz was sort of the person at RBC who led the charge on all of this, including having been involved in financing deals, and then going up through the entire process of the special committee, and ultimately providing the fairness opinion. And upon first meeting Mr. Munoz, I knew that I would have to spend many, many hours with him to try to get testimony out of him that was appropriate and to keep him from saying things that he shouldn't say. So I knew it was going to be a tough assignment, even if he was just a witness.
So, Joel, back to you. Now we are closing in on the scheduled date for the trial.
You just had me remembering my first sight of him at the deposition. But anyway. He was like, he never went to business. He went to Columbia undergrad, and I sort of had this mental image that he was to be a lot older. And he was probably like 10 years out of college and had square-toed shoes, which I'd never seen, and really slick-back hair, and really had this, I don't know, this Gordon Gekko, like kind of like young post-Gordon Gekko look to him. Anyway, sorry.
I will, as an aside, say that it was suggested to him before trial that he not use so much product on his hair.
Good. So we are closing in on the trial date, and then sort of at the 11th hour, you end up settling with both the defendant directors and Moelis. Can you walk us through the strategic considerations that went into that?
Right. So, I mean, we're sort of fast forwarding. So we're when you're shortly before trial, so we had our factual record that we had experts, and it was, I think, right around the time of like the rebuttal expert report. All of a sudden, we get all these new documents produced to us, and basically, like the theme was like rural metros on the verge of bankruptcy. That was so because we'd had a discovery dispute over post-close performance, and I think it was resisted. And then, what do you know? They're producing this voluntarily getting additional post-close performance data, and then when we went to a mediation a few weeks before trial. It was sort of presented to us, well, by the way, there's no D&O coverage or like very little, and the company's about to go bankrupt. And that, I'm paraphrasing, it's all, I don't know, it all became public, so whatever. Forget whatever was said in confidential mediation. But like the situation we were made aware of, it was a difficult situation. So anyway, so we were just looking, trying to realistically value the case and see what claims made sense, what defendants made sense, and I remember being most intrigued and saying Moelis was actually still intriguing to me, so I remember having a big long oral arguments with like the general counsel of Moelis, and that was one of the initial settlement. They settled for, was it $5 million or something, and then the outside directors settled, was it 6.5 something, So, and there wasn't much D&O insurance, and that was feasible. And then, but we did like the RBC claim, but they didn't seem, I never felt like they were taking the cases seriously. When I say seriously, I mean from like a value perspective, settlement perspective, as we would have seen value in that claim, because we had built up quite a record as to RBC.
Can I ask you about that before?
Sure.
Because we jumped over some of the discovery.
Yeah.
So from my standpoint, the case went to the settlement hearing. I rejected the settlement, put you all in charge, and then, as it usually happens, the case dropped off my radar as you all went out and did discovery.
Right.
And then it did resurface. There was a fight over the subpoenas to the bankers, where the banks took the position that there should be no discovery of any internal documents whatsoever, and that should be just the rule, even though it had never been the rule for 30 years. I was curious, like, at what point in the discovery process did you get traction? Did the motion to compel actually break anything loose, or what happened in terms of when you thought, okay, we've got something that we can get real money from and monetize here?
It's suggested to me from the audience that the answer is yes, but I think it's really schizophrenic the way I think of it. Like, I thought we were putting together like a really good case factually, and especially on the RBC side and their conflicts, which went way beyond staple financing. I mean, because I think really the story that came out of the record, which is I think virtually uncontradicted and uncontradictable, was that RBC was essentially, they were like true bankers. They were lenders. Like that they were really good as lenders, and they had very little capability or prominence as advisors. And the percent of money that they were hoping to get, not just from Rural Metro, but from another company in the same industry that was also having an M&A transaction, like they were envisioning in their internal memos that they could make up to $60 million in financing fees, while their advisory fee for the M&A was about 3 or 5, 3.5, something like that. It was really out of joint, and and there was no effort to like screen off lenders from advisors. Munoz as he put it, was working all angles on two side-by-side deals, on the lending side, and the advisory side, and the fairness opinion side. So we thought we had traction. So I always liked the case. But I'd say the word on the street was, this case is a zero. This case is nothing. And even, Your Honor, when you rejected the settlement, you were very, I would say your language was not encouraging to us. I mean, it was like this could be a great winner on 102B7. There might be a great defense here, but it barely makes it over. So we never. It wasn't like having. There was no motion to dismiss back then. So there was never like a judicial opinion saying, "Oh, these allegations look strong." So we didn't have like that external validation. But I always thought we were developing a good record. And from a word on the street perspective, it was like, you run into one of the lawyers, it was like, oh, this is a stupid case, you'll never get blood for us done, that kind of.
And did you have insight into the extent of the RBC issues before the motion to compel, or did that come after the motion to compel?
I remember the motion to compel being on the MOLA side.
It was. Yeah.
So there was like separate tracks, but it really was getting the documents on their conflicts.
Interesting. All right. Thanks.
Which went way beyond. Like the original deal file, or certainly from the disclosure settlement record.
Yeah, I will say that on the RBC side, we were overly generous with the production documents as a result of using computer technology, which was relatively untested. Counsel, who I stepped in for, had used it, and when I stepped in, the discovery was a mess. And one of the things I had to do was try to claw back as many documents as I reasonably thought I could, because there were lots and lots of documents about other deals and other things that had been produced. And so we were not the subject of a motion to compel.
How surprising was the settlement to you, Alan?
Well, the MOLA settlement really, I think, took us by surprise, because we thought MOLA's we thought we didn't face a huge risk of liability at that point, but MOLAS even less so, because they were sort of the add-on banker who were conflict-free and not providing financing. So the fact that they settled for $5 million, we thought, wow, that's interesting. Not sure why they would do that. And then when we woke up on Monday morning and found out all the directors had settled as well, we thought, oh no, we're the last party standing. I think we did have a conversation with Joel.
Yeah.
And Joel said, well, they were the first mover, meaning MOLAS, and therefore your settlement will be multiples of theirs. And so that's what we had to think about going into trial.
And at that point, Joel had dug up a bunch of unseemly exchanges. So references to manage Shackleton, let's get this baby sold, back channel communications, not on email, thought we were going to reduce DCF, et cetera, et cetera, et cetera, right? This looked bad on the outside. You, from the inside, did you have the feeling that these were as bad as they came across? Or were they simply a matter of a young, college grad student or graduate seeing himself as an expert on Gecko?
So, as a trial lawyer, you're never handed a perfect record. And when I say handed, I was really handed a record, because I was not involved in discovery of all of the rural metro personnel. I got involved really in the discovery right before trial. So it was for me, looking at the record, I was thinking, there are lots of problems with this record, but my job as a trial lawyer is to try to present our side of the story, number one, and number two, make legal arguments that can overcome that. And one of the things that we were looking at was, and this is something I think carried through the appeal, ultimately not successful, but was the idea that, yeah, the process was flawed. Yeah, there were people who said a lot of stupid stuff. Yes, the corporate governance was shoddy. But when you step back, this company was exposed to the market. It even after Warburg signed it up, it had 90 days for anyone to come in, including those people who had been involved in the AMR process, if they wanted to bid, and nobody came forward and bid. There were virtually no impediments baked into the merger agreement. So it really was kind of an open book, and people could come in and make a topping bid if they wanted to. Nobody came along, so our view was, there's a strong presumption that the market has spoken here. Obviously, you still have to deal with the idea that was it really the right time to sell the company, which is a different issue. But that was one of the strengths that we thought that we had.
And Alan's sort of underselling the Herculean effort that he put in, and so I think we ought to acknowledge that. I mean, so again, I didn't focus on the case except for this motion to compel, and then I know the pretrial conference is coming up, and I'm getting pretrial briefs and a pretrial order, and then I get a call to set up a conference with the parties on a Friday. And during that conference, Steve Lamb, who was representing Moelis, and Joel disclosed that they have this settlement. And there's a back and forth, and the director's counsel at the time, who's Bill Lafferty, he says, look, we need some time to figure out what we're going to do. We don't know if we're going to cross-claim against these folks. We got to talk about it, et cetera. I have clients all over the country. Can you just give me some time to deal with that? And so I gave them over the weekend so that the director defendants could get their house in order and figure out what's going to happen. And then we reconvened on Monday. And it was on Monday when I learned that the directors had settled as well. And as Alan says, that left him the last man standing. And at that argument, Alan made the pitch to me. You got to postpone the trial. We need a continuance. This really isn't fair. We weren't the primary defendants. Sort of as he said today, I didn't do a lot of the discovery. I think he said I was only going to have one witness at this trial, and now here I am. And Joel came back with saying, look, this is just a risk everybody faces. They filed pretrial briefs. They knew what they had to do. We just ought to go forward. And so I took it under advisement, and the next day said, all right, we're going forward with the trial as it happened. And so that really forced Alan and his team to get up to speed on this massive record. And I think that doing that and accomplishing that is something that we shouldn't pass over in terms of getting ready and being able to put on the presentation you all did at trial.
Yeah, and just to elaborate on that a little bit, especially for the students, you have to imagine. I had, at that point, as the Vice Chancellor said, planned to put on one witness. Now I had to put on all the witnesses for the defense. And all of those witnesses, except for Tony Munoz, who was my client, I'd never met before. I hadn't prepared them. They had their own lawyers. It was a very, very difficult process to do in a matter of only a few weeks.
So, Joel, at that point, you're left with RBC alone.
Yep.
What was your theory of the case?
Theory or fear?
Theory.
Oh, sorry.
Both, actually. But yes, let's start with theory.
Well, the theory was aiding and abetting, but I think what you really want to probably get to is we did not present this as this is going to sound crazy. We did not present this as a Revlon case. Okay? I mean, so the way you tend to think, the way I thought about the case or thought about cases back then was that if you have someone who has an undisclosed conflict, that takes you from business judgment rule to entire fairness, and that was like our main underlying theory, with this being an entire fairness case. And although the theory against RBC in particular was still aiding and abetting, that was like the doctrinal framework for the case.
So exactly what kind of things were not disclosed?
Well, that's a great question. No, there must have been something. No, well, I thought a huge part of it was I think the Shackleton conflict. So as we got into discovery and got discovery from Shackleton's hedge fund or PE fund, whatever kind of fund it was, and we got their internal documents, you could see why they wanted to sell. And they had multiple reasons of wanting to sell and wanting to sell quickly. Not only was this now 20% of their fund, and not only were they a young fund and looking to grow and looking to record this as a big win, which they could then market for their next fundraising round, but also they had a very particular sense of a holding period and a very particular sense of investment strategy, what kind of companies they were looking for. And this CEO and the acquisition strategy was like brand new for rural metro. And it did, and as soon as that CEO came on board and had this strategy, they wanted to get out. And that's why they were initially mad at the CEO for not being seemingly cooperative in the first people to express interest in buying the company. So they really wanted to get out, and there was no conception on the board that this 12%, that this guy, like imagine if a bunch of like retired standard outside directors, and then you have this, again, like 32-year-old Yale grad who's just like, I'm going to do everything. I'm the chairman of the board. I'm chair of the special committee. I got 12% of the company. I'm going to arrange, I'm the one sending every email and arranging the deal. And the fact that he was conflicted that's the one that sticks in my mind the most. But maybe my colleagues will have other ideas.
Okay, so Travis, this is on your desk now.
Yes.
What was your theory of like this, and why did you decide to rehash it from Joel's proposal to what ultimately?
So I actually went back and looked at the briefing because I was like, did Joel really brief this as an entire fairness case? I mean, what went on here? And so it's mainly a fact presentation from the plaintiffs. And then you step through aiding and abetting. And so is there a fiduciary? Yes, there's a fiduciary. Is there a breach? And what you all pitched, at least in the briefs, as I look back to refresh my recollection, is you pitched care, used the gross negligence standard, but then cited a lot of the cases about that came from the sale environment, where they say things like a board has to act reasonably. Directors have to be particularly vigilant in the sale context, things like that. And so, from my standpoint, I was running an aiding and abetting analysis. So clearly there were fiduciaries. Then I'm in is there breach? And so for me, it was a sales setting. I was getting citations about reasonableness cases, and to me, it just had the look and feel of a Revlon case. And I think this is one of the decisions where, I don't know, it wasn't the first, Trados was probably the first, where I ran through the standard of conduct, standard of review distinction. So from my standpoint, when it came time to measure where the fiduciaries, what they were doing and whether they'd actually committed a breach, I had to apply some sort of standard of review. And so then the question was, what standard of review would I apply? And again, for me, this was a sale for cash. So it was an enhanced scrutiny situation. And at the time, and I think still there is in Delaware law, there's this question about whether enhanced scrutiny is the only standard of review that only applies in the injunction phase and then disappears after that. So normally when you apply a standard review in the injunction phase, you take whatever is the standard that you would apply at trial, and then you bring it back to the injunction phase by asking whether there's a reasonable probability of success on that standard that would apply at trial. But there's this authority in Delaware that says uniquely enhanced scrutiny isn't that way. Enhanced scrutiny is the only standard in the law that only magically applies at the injunction phase and then poof disappears for the rest of the case. And that never made sense to me. And I was, and I still am of the view that we have these three standards of review, and they're each standards of review, and they each apply in different circumstances. So to me, this just had the look and feel of a Revlon case. I had to apply a standard review to figure out what the breach was. I'd been, given these cases on reasonableness, a triggered range of reasonableness in my mind. So it's sort of all set up in my head in terms of as I was stepping through. Much to your later chagrin, I know.
Well, I mean, looking at the case overall, the prosecution of the case, I think of it as in three phases. Where I feel like it was our case. It was like we're building the case, making the case, everything from that disclosure settlement through trial and then post-trial briefing. Then there's three post-trial opinions. And then I realized it's no longer our case. It's the Vice Chancellor's case. And it becomes his case. Like he makes it his own case. And in terms of like legal doctrine and especially. And
you're stuck defending it.
No,
on appeal, I mean.
But I remember, I was just reminded reading the RBC opinion of the Supreme Court, we actually argued you could affirm on an alternative ground.
Yeah.
Like, if you don't like this reasonableness stuff, you can still say it's entire fairness. And actually, that's like the third phase. It was like, okay, the Vice Chancellor has 3 post-trial opinions, and then it seemed like a year and a half after trial, we're before the Delaware Supreme Court, and you realize, well, they're going to look at this completely afresh. There's been a ton of changes in practice. There's been, every law firm has weighed in. There's a couple of amicus briefs. Like, what's going to be appealing to them?
Academic articles have been
Academic articles have been written. Business lawyer stuff have been written. So that to me is like phase 3. So in phase 2, and I'm just saying this like for historical purposes because now there have been so many decisions about Revlon as a standard. I remember you gave a speech at Penn, and that was like probably 2017.
Yep.
But this is 2014, and it was by no means clear that Revlon was going to be a post-trial standard. And frankly, as a plaintiff, I think we would rather have an entire fairness as the standard.
Sure. Yeah.
So exactly in what ways did the defendant's behavior fall short of a range of reasonableness? Can you give us a couple of examples?
So, I mean, again, from my standpoint, let me count the ways. I mean, and again, these are decisions that can't be divorced from the credibility of the witnesses and the evidence at trial. I mean, I'm sure that there are many people in the world who love Mr. Munoz. I'm sure he does a lot of great things in the world. I'm sure he has, kids that he loves and is fantastic in many settings. He just, at least at that point in his life, struck me as a not at all credible sales guy who was just there trying to make a buck and was willing to say anything to anybody to get this deal done. And part of what I remember at trial is he just kept getting impeached, and a question would ask, and he had this habit. He'd get asked a question, and he wouldn't directly answer the question. So if you'd ask him, okay, does 4 + 4 make 8? He'd say, well, it's one of the ways to get to 8. And so he'd always give you an answer that sounded like he was answering the question, but didn't actually answer the question. And I realized, like, this is actually an art form. This is a little bit like being a great poet or something of that ilk. And that this was probably a key to his success as an advisor, is that he would get asked questions and he could give one of these malleable answers where people could hear whatever they wanted to hear in the answer. But from my standpoint, that was evasive. And then he would often get impeached on it and pinned down. And so from my standpoint, he ended up looking like a guy who really had manipulated things. I bought Joel's account in terms of Shackleton, that he was also a young guy, eager, trying to get these things done, trying to make everything happen. And so those two folks for me were at the center. And in terms of what the board did, really it was from the other director's standpoint what they didn't do. So they let Shackleton. They tell Shackleton in substance, look, we think we might want to explore strategic alternatives. Why don't you get a banker? And Shackleton is supposed to hire a banker. And his message to the rest of the board is, oh, well, you guys don't need to be involved in this. We're just going to have some interviews, et cetera. He ends up hiring RBC, and it's clear from the contemporaneous documents that RBC understood that they were hired to sell the company. Like, the decision had already been made at that point. We're going to sell the company. And so Shackleton and the banker were way out in front on that issue. Now, okay, that can happen. But when the board learned about it, there wasn't any effort to rope them in, and they weren't even involved for, I don't know, several weeks. And then nobody did anything. Nobody engaged in any type of adult supervision from that basis. So that was point number one. Another thing that really struck me was the reasons that RBC gave for selling the company at the time they were supposed to sell it. And it was all about how the timing was great because there's this other sale process going on for EMS and AMR, and there'll be synergies off that, and people will be looking at that, and then they'll look at us, and they'll maybe want to combine the company together, and wow, this is a great time. And if you just stopped and and thought about it and looked ahead at what was going to probably happen, you're going to see that that wasn't a good thing. That was real problems, because those other bidders were going to enter into confidentiality agreements as part of that other sale process. And then they weren't going to be able to participate in the rural metro sale process. And so a lot of qualified bidders were going to be knocked out of the game. And I remember one of the RBC witnesses at trial was asked, well, isn't that something that you guys ought to think about? It doesn't seem like that big of a complex point. And they're like, yeah, it's pretty easy to foresee. Okay, well then why are you doing it that way? And then as the sale process unfolds, they start getting feedback that not only was this something that one could foresee, but it was actually happening. So they get feedback from a couple major PE firms that are actually telling them, look, we can't do these both at the same time. We would really want to stagger these, et cetera. And so again, there just doesn't seem to be anybody providing adult supervision as these folks who really want to sell the company are doing their thing. And then again, as I explained in the opinion, at the final sort of critical moment, the RBC folks again are just sort of cut loose to have the discussions they're having with Warburg, and they're trying to sell Warburg on getting into the financing package. So there's this whole arc that to me seemed to be a scenario where there were a couple motivated directors, and it was mainly Shackleton, but then Domino, the CEO, came around, and there's
Eugene
Davis. Davis was also interested in getting the company sold, and it seemed to me that they were just doing whatever they could, and the board just wasn't doing what it should have been doing to exercise a good supervision and pull people in. And as a result, they ended up with a bid with Warburg that Warburg itself acknowledged. They were able to have all these advantages and get this deal for what they thought was a great price. It didn't turn out to be a good deal for them, but at least at the time, they thought that they'd gotten a good price. So it was that sort of combination of things from start to finish that I thought was problematic.
You said a moment ago these guys were interested in a quick sale. Was that degree of interest of a magnitude that would allow a case against them to survive 102B7?
So, I mean, what I ultimately said in the contribution opinion was that at least as to Shackleton and Davis, their interest in a sale and their personal interest, Davis was overboarded and he had an interest in getting off the board. Shackleton was really focused on his fund rather than being focused on the company. And so good faith in my world means you have to subjectively believe that what you are doing is in the best interest of the company. And you have to, and ultimately it's stockholders. And you have to focus subjectively on that end. That has to be the end that you are focused on. And what I instead had was two people who were not subjectively focused on that end. Davis was focused on an exit that would make him look good. He was a regular player in terms of these things for private equity firms, and he would solve his overboarding problem. And Shackleton was mainly focused on his fund. So I would say that yes, that was enough, and I did say that they could have been held liable, and 102B7 wouldn't have protected them. But it's not simply the we want to sell now conflict. If you want to sell now because you think selling now is the best thing for the company because who knows, interest rates are being subsidized, or you're the provider of VHS videotapes, and things are going to change in a few years, sell away. But you have to sell not because you want a big coup for your young hedge fund. You have to sell because you think it's best for the company and its stockholders. And I didn't think they were selling because they thought it was best for the company and its stockholders.
So the trial hearings and so forth conclude, and you tell these guys, okay, I'll get back to you in 90 days.
Yes.
It took you quite a bit longer, and one of the interesting plot twists in the interim, Rob, is the company filed for bankruptcy. So that's something that Joel already alluded to. Can you give us some backdrop on that?
Yeah, this rural is still a raw wound for Warburg. We bought it in 2011, and I think within a year we began to realize that there were really significant accounting issues revenue recognition issues at rural. And as I recall, in June of 2012, about a year after we bought it, we hired EY to come in and do a whole analysis and look at our revenue recognition systems. That resulted in a significant write-down of AR receivables. We did the acquisitions, part of the growth strategy that people were buying into. Turns out those acquisitions had problems, and in February of 2013, we hired a whole nother set of advisors, FTI, Marcel and Alvarez, to look at our systems again. We did another big write-down, and then we did another big write-down in the spring. And so what did Hemingway say? How'd you go bankrupt? Gradually, then suddenly. That's what happened. And so the company filed for bankruptcy in August of 2013, really 2 years after we bought it. And it's a raw wound because, to add insult to injury, we then we lost all our money. And then we got sued by the bondholders because they claimed that we misled them. I mean, we controlled the board. That we misled them in their investments in the bonds. Kind of a case we ultimately end up settling, but that was an added aggravation.
That bad acquisition, that was a post-close, that was like one big post-closing acquisition that was.
Yeah, there were two actually, but yeah, we did.
Okay, one was worse than another, right? It was like.
Yeah, that may be right, yeah.
Travis, is this something you could pay any attention to as you were thinking about the fairness of the price?
I mean, I held that I couldn't. In appraisal and evaluation generally, we will consider post-close evidence, but it's it's usually proximate to the transaction, and the idea is just to sort of see if there's something there that people were saying about the events that happened retrospectively at the time, because you're focused on the valuation date, you're focused on the transaction date, and what the economic conditions and value and market conditions were then rather than later. So when I got this motion to supplement the record, I mean, I did think hard about it, but it struck me that this was evidence that first of all was well after the time of the deal. Warburg had done some things, not only these acquisitions, but they'd leveraged the company up, they'd accelerated the strategy, and what happened after it got to their hands was sort of their problem. So I ultimately held that I couldn't consider it, and it therefore didn't play a role after that.
So ultimately, Travis renders his decision on liability, then on damages, and then Alan, the ball is on your court. How are you thinking about the appeal?
Well, an appeal, of course, is a completely different ballgame because you're stuck with the record below. One of the things that we considered and quickly rejected was sort of the idea that it wasn't right that we weren't given more time, for instance. And that's all a matter of docket management. So it's just a complete loser on trial, and you would never bring something like that. But so we really focused on legal issues, and legal issues that I think were questions that not only RBC wanted answered, but also the entire corporate governance community, because in one way, at least, to read the Vice Chancellor's opinion is that essentially the bankers were going to be guarantors of the director's conduct during the process.
A different G word. Yes.
Yes, gatekeeper. And so we argued, strongly that they shouldn't be gatekeepers. That to the extent that there were breaches of fiduciary duty, that we were on the outside, we were an agent, and that there wasn't enough evidence as a matter of law to say that we had knowingly participated. So that was one of the core arguments. And the other one was the one I mentioned before, which is that when you back up and look at this from an economic standpoint, and having exposed the company to the marketplace, you're talking about a company that was trading at $9 for many years, had gone through a bankruptcy, and then was trading at $9. And when AMR was in play, the price went up to 12. And ultimately it sold for 17 and change. And it was exposed to the market, no one else bid higher. It was sort of like, what are we doing here?
Were you optimistic about your prospects at that stage?
You're never optimistic when you're the appellant. You're hopeful.
So ultimately, the Supreme Court affirms that it's not a one-pager. They write a hefty 60-page long decision. So I will not ask you, Travis, to comment on the people above you, but Joel and Alan, maybe do you want to comment on the main similarities and differences between the law as interpreted in the Supreme Court's decision and the one in Travis's decision?
Would you mind if I commented on sort of my thinking before that decision? Because obviously the decision's there to be read, and I guess we can talk about it. But for me, this was the most perilous time in the case because everything is being looked at afresh. Like this whole question, when does Revlon apply? Yeah. Which I remember was the first case I worked on as a clerk, in 1992, was when does Revlon apply? And here we are in 2015 briefing up. Did Revlon apply at the last moment when they sold the company, or did it apply, for the 6 months in advance? And the Supreme Court, basically said for very fact-specific reasons, weird reasons, Revlon applies the whole period of time.
Right, and Lyondell had just been decided.
Yes.
Yeah. So but also in the press, there was this bizarre reaction. Actually, so there was one reaction which was nobody felt sympathy for RBC on the facts. Everyone was so the reaction seemed to be very bad facts, maybe bad law. Wachtell was out there with a memo private ordering and contractual relationship with bankers, and this is all overlay of tort theory. It's all very problematic. But there was also this other feeling, I remember this in the Deal book, the Deal professor, that somehow it was unfair that the bankers were being tagged but not the directors, and which struck me as just completely, utterly bizarre. But this realization that the Supreme Court could look at everything all over again, and actually the stuff about price discovery, I wasn't worried about the factual record at all. There was this magical document from J.P. Morgan where, oh my gosh, what's his name? The great writer, former Goldman Sachs, Wachtell, Matt
Levine?
Matt Levine had this great column where he dropped this footnote, how insane is it that the CEO in the middle of a process takes a random meeting with another bank? And J.P. Morgan had this book saying, well, obviously you're not going to sell the company now, but it would be great to sell the company in about a year, after these other companies do their deals and after you prove out your acquisition strategy. So I felt very good on the facts and the factual record. It was really about these fresh questions about, how would the Supreme Court look at this whole melange of public policy issues?
Systemic issues.
Yeah, one other thing that, was, again, something that we strongly considered, but decided not to appeal on was one of the, I think one of the ways that the Vice Chancellor got there on RBC's liability were these supposed discussions between the head of financing at RBC and the folks at Warburg that happened during the same weekend that there was, it's the only time that any senior banker actually looked at the fairness opinion. There had never been any discovery on those discussions. The only thing in the record was some testimony by Tony Munoz saying that, in fact, this conversation took place. And then on the Warburg side, there was a witness saying, yeah, I talked to people at RBC, but there was never anything about the substance of those discussions at all. And the Vice Chancellor found that there was something inappropriate about them, or that there was an effort.
Yeah, effort to get it on financing. That's what I inferred. Yeah, that's what I inferred.
Right, and so, that's to us was the only fact issue that we seriously considered, and then ultimately decided we weren't going to get any traction with it.
So let's step back a little bit from rural metro per se and look at the context in which this is taking place. There was a sequence of decisions on banker conflict, El Paso, Del Monte, rural metro. How did this triad of cases, if you want to call it that, change practices in terms of board behavior, in terms of banker behavior, in terms of market practice?
I think some of it had already begun to occur at the time of the rural metro deal. There had been some case law about the importance of bankers disclosing their conflicts. Do they have, who else do they represent? Do they have an interest, indirect or direct, in the selling company? And so even at that time, I think there had been a focus on practitioners on better disclosure, boards requiring better disclosure by sell-side advisors of potential conflicts. And I think that had just begun. I think we talked a little bit before on the skepticism in the professional community about staple financing, particularly in the public context, and I think that had begun at the time. I think what rural did is it heightened the scrutiny of those kinds of behaviors going forward. I think about fairness opinions. Even back then, there was a notion that if you have a banker, your primary banker, who's supposed to give a fairness opinion, and there's a transaction fee that's highly contingent on the success of the deal, the opinion fee, might get folded into that. Is the opinion fee contingent in some way on a successful deal or a successful opinion being rendered that the deal is fair? But even back then, people were saying, okay, that's an issue. So what you do to solve the problem is you get a second banker. And that second banker doesn't get a contingent fee. You get a straight flat fee opinion fee that's paid as long as you do the work. And you get the fee regardless of the opinion rendered. So I think even at that time, there were practices in the professional community that, again, I think were highlighted in rural metro, and going forward, just I'm not sure it was all new, but it was like I say, heightened, and people paid attention to it.
So, a couple of years after rural metro, we have Corwin. So, Joel, can you tell us a little bit about how this case could have looked like or would have looked like in a Corwin world?
Yeah, I think that's a great question. There's also another meta question about the legacy of this case, which is I think the reason Corwin was not extended, there's definitely a movement to roll back all what our friends at Wachtell would call third-party non-conflict deals. Like somehow a private equity deal is a non-conflict third-party deal that the Court of Chancery should get out of the business of regulating. And I think absent rural metro, like that effort probably would have succeeded. And sure, I mean, there's an ongoing, but so, at any point in time post-Corwin, the post-Corwin law was in a state of flux. So if we're trying to think of it like as of today, like current practice, it subsequently evolved that you get access to 220 documents. So if we had not just board documents wouldn't tell you much. If you can get through 220, those board level emails with Domino and Shackleton, that would be interesting. The Coliseum stuff, back then there was no concept of really motion to dismiss practice. I mean, a Revlon case was not subject to motion to dismiss. I don't know. It's all very tricky. It's hard to imagine, sort of how whether the aiding and abetting or is there enough on Domino that he was personally interested or Shackleton was personally interested and there wasn't an effective process?
I mean, you've made this point, Joel, but it's worth remembering. So, I mean, Monteverdi was in there on expedited discovery, right? And the defendants had stipulated a discovery. So you're absolutely right. Like he's getting sort of what was at the time the agreed upon package of documents that one got before one did a disclosure on the settlement.
Plus depositions.
And then he got I don't remember whether the depositions were post-MOU or pre-MOU, but he definitely got more than you would get on 220 today, I think.
So, Travis,
let me just jump in. There's been a couple comments about Shackleton and being conflicted, and I'll speak on behalf a little bit of the private equity world here. And we worry about this. We think about this in light of cases like Rural Metro and the atmosphere. But the mere notion that a private equity sponsor, because of a desire to exit, to sell its interest, either because it's held it too long or because it wants to raise another fund, I don't think the law is that standing in and of itself gives rise to a disabling conflict.
Yeah, agreed.
So then the question is, what more does it take? Does it take and maybe Shackleton, given how he sort of commandeered the special committee, was a step too far? But, an email from, a deal from the CEO of a private equity firm to the deal professional in charge saying, look, it's time to sell this company. We've held it long enough. Is that enough? So those are the kinds of things in real life that we pay attention to. We don't think it is, by the way. I think you have to pair it with some sort of other more egregious behavior.
Well, sometimes I wonder if the motion to dismiss standard is actually higher than the trial standard. Because if you have a trial, and Vice Chancellor was explaining about his perception of Tony Munoz or Chris Shackleton, you can actually make a finding that this person was motivated by this conflict. Now, ironically, without the discovery, the same court, the same judge on a motion to dismiss record can say, you haven't pled a sufficient conflict. So this conflict is actually sufficient to motivate the person that could lead to actually proof by a preponderance of the evidence that this is why they did the deal. But you can have a motion to dismiss saying, oh, it's not really reasonably conceivable because this kind of conflict is not legally cognizable. It's a very weird disjunction.
And we don't view that as a conflict. We get asked this question all the time. If we're in the sell side scenario, you want to sell, we've got to form a special committee of independent directors to cleanse the transaction. Our view is no. Our view is, look, we're the largest shareholder. Our interests are totally aligned with the public shareholders. And absent some weird facts or absent us receiving disparate consideration or disparate treatment, we are the best position to represent the public shareholders.
Can I do a really quick anecdote from the case? So I was deposing Eugene Davis, and it said, I was asking him, it says in the board minutes, that he asked the question, is Shackleton interested by reason of the fact that he owned 12%? And I said, what's that doing in the board minutes? And he said, because I knew I'd be right here, I'd get asked that question, and I was going to get an answer, and that he wasn't conflicted. I said, well, did you realize that the person you asked the question to was actually Shackleton's lawyer at his fund? Oh, no, I didn't know that.
By the way, that was one of the only sets of minutes.
Travis, you sat on this for way over 90 days.
Really?
Yeah, the trial was on May, and the decision was in...
There was
post-trial briefing.
Okay.
It runs from the completion of it runs from the date of post-trial argument.
Scratch that.
Now look, there are times when in Columbia I went over 90 days, but I think I hit it for this one. So I have to defend myself.
What would you say were the main doctrinal innovations in Rural Metro, and what gives Rural Metro a shot at being an iconic case?
I think Royal Metro is an iconic case, and obviously I have a little bit of a self-interest in that, having been part of it. But I don't think it's just doctrine, right? I think I group it in three headings. I think about sort of the impact among our culture, because we're all part of this M&A community, this broader M&A community, so I think it affects how people think about things. We've talked about the effect on practice already. I do think that there was an acceleration and a heightening of practice points in terms of disclosure letters and things like that. So I think it had that dimension. And then I think there's the doctrinal side. I almost think it's iconic mainly because of the effect on the thinking of the community. When you think about the big cases from the 80s, there are all these cases that changed how people thought about deals. So, we all think of Van Gorkum and whatever you might think about the actual merits of the decision. there's basically broad agreement that it changed how boards approached M&A transactions. It changed how people thought about these things. And so I think rural metro to some degree had a lot of that effect on the banker relationship. Before, and you've talked about the triad of Del Monte, El Paso, and rural metro. And before that, we were in the Rob Kindler era of, we're all conflicted, get over it. And I think he offered that as a laugh line, but for whatever reason, it was embraced as truth. And we all of a sudden pivoted to this idea where conflicts are fantastic and they're what make deals happen, and we ought to just turn a blind eye to them. And I think this trilogy changed the thinking on that and said, no, actually, we understand that bankers' relationships can be value add, but there are some conflicts that are really problematic and that you have to deal with, and it's not a free pass. And so I think that was a shift in cultural thinking in the M&A community. As I said, we've talked about the practice a little bit. Doctrinally, I think a couple things. And I don't know, again, I tend to resist the idea that I'm coming up with doctrinal innovations. But I think this was the first case that treated aiding and abetting as an actual thing, rather than just something that got dismissed at the pleading stage and really didn't have weight. And again, it wasn't new. The aiding and abetting law was there already in motion to dismiss opinions. It was there in the restatement of torts. But it had just nobody had actually proven up the facts necessary to get to an aiding and abetting result. I talked a little bit earlier. I do think that it was a key case in terms of the development of enhanced scrutiny as a fully worked intermediate standard. And from Koster v. UIP, we now know from the Delaware Supreme Court that's indeed what enhanced scrutiny is. But this was a step along that path. And then I'll steal a little bit of Joel's thunder here, and I hope not too much. But I do think it was a key example of how deal litigation can be real. And I think that coupled with El Paso and some other cases was important in establishing that. So again, put yourself back in this world where literally 97% of deals are getting sued on. And virtually every one of them is resulting in a disclosure-only settlement. And what that ends up doing is it makes litigation look like just a sunk cost for society. It is nothing but a sunk cost. And meanwhile, there's no actual enforcement of norms because everything gets settled. And so really, who cares what you do in terms of the boardroom or practice or conflicts or whatever? Because look, we know that somebody is going to come along and we're going to settle with them for disclosure, and boom, boom, we're done. It's all good here. And so there was this real sense that disclosure litigation was nothing but a racket. And as practice at the time, I think it was. And I've said this many times in transcripts. I think it was an absolute racket. And so what I wanted to see, and was very important to me, was that good cases get litigated and bad cases not even get brought. And so what I think I and my colleagues had started to do, and by not approving some settlements and things like that, was to say some of these cases shouldn't even be brought in the first place. But what there needed to be on the other side was examples of situations where there actually was a real recovery and a real benefit. I credit Joel with putting together the factual record. The law only applies if the facts are there. Joel and his colleagues and Jeff and Randy, they put together a record that showed how M&A problems could exist and affect things. Pache Allen, I totally understand the argument about post-market check exposure, but at least in terms of the original deal, how they can really taint things. And I think it was a validator on the other side of the coin as to why we actually have stockholder litigation. And we have it because it does, in important cases, have a beneficial check and a way of enforcing norms, which is not why we need 97% of deals sued on. But it's hard to think about that today because, to the plaintiffs' bar's credit, and I do give them credit for this, we have moved into an era where they are picking their cases. And it's to my colleagues and my detriment, because we now get these complaints that are like 100, 150 pages long. And they really only come in if they've done 220, if they've gotten things, and if they've actually sort sort of got something they think they can litigate on. But I think it's been a big shift in terms of sue on every deal to now, and we normally cite Corwin and Trulia as the gateposts along that march, the mileposts along that march. But I think rural also deserves status as a milepost along that march.
Oh, I'll go beyond that. I think rural's bigger than Trulia or Corwin. I think it'd be hard pressed to find a more iconic case, because I think it's because of rural that we got Trulia. I think rural really put an end to disclosure settlements, because this idea, actually you can't ex ante, like I think Bill Lafferty said, like this was like a zero case. This was a nothing case, and we somehow made it into something. It was perceived as a nothing. But the idea that, like because of the rural metro outcome, I think that's when you had more rejections of disclosure settlements, and ultimately Trulia cited this case very prominently. It was discussed. Second, I think the reason that Corwin doesn't go beyond where it goes, the fact that we now have 220 practice, after Corwin, so that there was not this successful effort just to essentially eliminate deal litigation, in the same way that MFW purported to just get rid of going private litigation, is because of this case. So and just whatever the impact it had on Wall Street practice as well.
Right. So before I turn it over to the floor, I'd be remiss if I didn't, circle back to where this all began, and that's with Randy. So this deal was announced on...
This is like cold calling. Are we allowed to cold call?
He saw it coming.
I've got some people I like to cold call.
That's very Jack, I'm a law professor. So the deal was announced on March 28, 2011, and then 10 days later you bring the case in Arizona. What made you at that point think you had a winner?
Until he got my letter inviting him to come to Delaware. That was, as the Vice Chancellor said, this was the era still that everything was being sued on. I was doing it different. I was trying to sue on cases and then find something, get expedited discovery, and then bring that case and not just settle them. And when I did that, then I got the call from Bill and said, come to Delaware, we'll give you expedited discovery there. I'm like, great, like that was ideal. I want to sort of emphasize the one thing that I think the Vice Chancellor said, that I actually think that there's the El Paso Del Monte rural triple that they can prove, but I actually do agree that the rural goes with Trulia and Corwin, and because the Vice Chancellor recalls, the standard for the objection was really unclear, right? We had previously brought Pure Resources where Chancellor said the challenge for that was basically ineffective assistance of counsel. So really, to even get that case was really a big win for us, and I think it was a really harder decision for the Vice Chancellor because there was all this peppercorn idea. There's a peppercorn, you can settle them, that's what everybody wants.
It's way bigger than El Paso, because El Paso was like a $25 billion deal. So we had like the same recovery here as in El Paso. So that was the settlement for like a penny on the dollar, and here we got like the full dollar. So that's how I always talk about mediations. Like, just because someone else sells a case for a penny on the dollar, why should I sell a case for a penny on the dollar? But,
although it wasn't a big focus of this case, but some other cases I talked a little bit about private equity on the sell side, private equity on the buy side. In a go private, we weren't caught up in this case. Our conduct wasn't questioned. I actually think we behaved pretty well in resisting the entreaties of RBC to continue to come after us to use their financing, and we didn't want to do it. We thought it was weird, actually, and made us suspicious. And we knew of Del Monte at the time. But on the buy side, we don't want to get tagged with aiding and abetting. I think it's a hard standard, knowing participation. Having said that, when we do go privates, our deal professionals, we tell them, first of all, there's nothing private about going private, so be careful. And we try to kind of try to play fair. There's the classic example, and there's cases on this, is the CEO wants to sell and get a second bite at the apple, and they only want to talk to private equity sponsors. And we're cautious in that scenario. Look, it's a competitive world. We want to have good relationships with the seller. We want to win the bid. But we also want to, we tell the CEOs, look, don't get ahead of your board. Make sure your board's involved. So that's kind of the way we view it. Mm-hmm. So I think, again, that wasn't this case, but the other cases are all sort of around that point.
Well, it was certainly atmospheric, because I mean, I remember being part of the problem of the sale process is the strategics were also disabled, so they only went to private equity, and it didn't seem to me to be a coincidence that private equity would need RBC, or RBC thought that
Domino, right?
Domino thought that he'd get the financing fees from a private equity shop.
So I'm sure people in the room were biting their tongue as I asked my question. So now it's your time.
Well, we actually proved loyalty claims against two of the directors because there's common underappreciated fact of rural metro, and it's clear in the Supreme Court decision, is that in the allocation of liability, there's an allocation to Domino and an allocation to Shackleton. So they were found to be common liability, not protected by 102B7 for the process. So we settled it. Oh, I'm sorry. So yes, so this is a pure tactical thing. After we settled with the outside directors, since we wanted to maximize the recovery against RBC, we said they had aided and abetted a breach of the duty of care by the board. So, so this is like a tension thing, which is we actually very aggressively, Jeff Gorris did a great job with Shackleton, very aggressive, and Randy with Domino, aggressively cross-examined Domino and Shackleton because we didn't want to show that this was like a textbook sale process that was all hunky-dory, that it was actually a deeply problematic sale process. We did that knowing that RBC had cross-claimed and put in a claim for diminished recovery under Ducata, joint tortfeasor liability. So we took on that risk in that case of getting a smaller piece of the pie in order to establish that these guys did some weird things, but the position we formally took was the board had breached its duty of care and whatever. I don't know what we said. There was not evidence of bad faith by Domino or Shackleton, but that 100% of the monetary liability should be attributed to RBC as opposed to common liability with others. But we did prove it, actually. We pled it, we settled it, and then we actually established that they did not survive. So it was found on appeal that they had peculiar reasons to sell, and they acted on that, and therefore ran an unreasonable process.
But once you settled, is the idea that once you settled with the directors, you didn't want to make them be so bad because it would impact the contribution? Yes.
We wanted to, on behalf of the class, as fiduciaries for the class, we're trying to maximize the recovery, and we argued that RBC should be solely responsible.
Very good point.
But I'm saying we actually created the record knowing that this was an issue to be adjudicated at trial and post-trial, and there was a whole separate opinion about that.
Vince?
Yes, I guess this is the question maybe for the Vice Chancellor, but it's related to that. It's about what it means to aid and abet negligence. I understand aiding and abetting intentional actions that are wrongful. I've always been confused by this opinion because it seems to me that almost a non sequitur to aid and abet
A legal fiction, perhaps.
unintentional behavior. So I understand the idea that there might be some kind of tort claim that rural metro would have against its advisors, but I have a harder time understanding the kind of conceptually wrapping my head around aiding and abetting negligent behavior.
Yeah, so I probably can't convince you, since I will do nothing more than recap what I said in opinion. But from my standpoint, the aiding and abetting concept, you first have to have a breach of duty, and any breach of duty counts. And then, so that means that a care claim counts for the breach of duty. So then what you look for is the knowing participation in the breach of the duty. And as I think I used this phrase in the case, the knowing modifies participation. It doesn't modify the duty that gets breached. And so what the person has to do is, for an aiding and abetting claim, and remember, aiding and abetting is technically different than conspiracy. Conspiracy is we have an agreement to do something. Aiding and abetting is you give substantial assistance to the breach. So if someone knowingly creates the condition where the other person acts in a grossly negligent, uninformed way, that's what I thought of as the means by which you get this necessary scienter component and end up with the knowing participation in the overall breach. And for me, at least in rural metro, it seemed to me to be a clear case for it, because as I saw it, RBC was really creating this informational vacuum for the board. They knew what was going on. Munoz, he was in the middle of it. He was pulling all the strings. He was basically on every side, and they were, again, from my standpoint, intentionally doing things to get the board to where they wanted to be. One of which was not providing any valuation information until the final book. And again, that to me was a shocking thing. They rolled in with their initial pitch book. They had some valuation information in there, and then they did not provide any type of valuation until the final last minute. Not because they didn't think about it, but because they intentionally weren't providing it. They didn't want themselves to get themselves locked into numbers. They hoped to provide the staples, so they didn't want to be in the position of saying anything about fairness. And so from my standpoint, it was the creation of the problem that really rested on their shoulders. And I guess my last thought would be, I do think that in this sense, aiding and abetting is perhaps separate from conspiracy, because you don't have to have this requirement of a shared mental state. What you're dealing with is this substantial act, usually framed as substantial assistance, that gets you to the breach. So that's the best I can do for you. Yeah.
Can I?
We started a couple minutes late.
We have a couple. Okay. So the way I'd answer it is, I think on these facts and generally the way Revlon's interpreted as a duty of active oversight. So the idea is if the aider and abetter is undermining the oversight, and there is not actually great oversight being taken place by the board, and there was all sorts of questionable stuff by the board about how much they were overseeing the bankers, and then were the bankers like feeding into that, as the Vice Chancellor said, then doctrinally it's not problematic. I think when it is problematic is if the board is actually asking questions and seems actively involved, but they're getting duped. If they're purely duped and you can't even fairly accuse them of being grossly negligent, not even grossly negligent, but not even being negligent, like under Revlon, if Revlon's just, are you actively, reasonably acting oversight? And they think they are. And that to me is like the hole in the law, which I wrote a law review article about, saying that we should get rid of that element for banker liability or for aiding and abetting liability. But that's what makes it problematic, but not on the facts of rural.
Anyone wants to ask the final question?
Question for Alan. Alan, you said you got brought in late, and you did. Were you able to participate in the document discovery depositions, and if not, how did that impact your ability to defend the case?
Able to participate in?
Document discovery and depositions, since you got brought in very late.
Yeah. So all the depositions had taken place before I got involved, except for my witnesses, and I think there was a second deposition, or maybe it was the only deposition in Domino that I attended. But at that point, I don't know that I was a party, but those are the only two that, and all the document production we were not privy to at all. It was all dumped on us after that March date.
Yeah, I mean, you undoubtedly would have done the document production differently. I mean, you would not have done the TAR. I don't think, would you? Right?
Yeah.
Okay, and with that, I think we are at our deadline. So please join me in thanking the panel participants for a great discussion.